Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing formalization of a will here in the Kingdom of Thailand. And we're not talking about sort of probate issues, anything like that. Basically, the thrust of this video is signature issues, witnessing issues, which will vary from case to case, depending on circumstances. Different types of wills, and in my opinion, there's multiple different ways you can formalize a will in Thailand. We do the vast majority of our will formalization in one way. There's different ways it can be done, but quite frankly, there's, for lack of a better term, there's the ways that consistently work, and there's ways that do not. And depending on how a will's set up, for example, like a will that is filed, for example, with a civil registrar is going to be dealt with differently than what's called a holographic will, which is like a handwritten will. And those are going to operate differently than what I think of as kind of a standard will, which is just a will that is written up, written down, reviewed, and then, it's signed by the party and it's witnessed according to laws on formalities here in Thailand regarding the witnesses, regarding whether or not it needs to be notarized, etc. So it's going to vary a little bit depending on how the will has been drafted and how the will is maintained, in a sense. It will vary from case to case. I know folks think I'm kind of a broken record with that, but yeah, it does. It varies from case to case. Those who are looking at possibly drafting a will in Thailand, or they already have a will outside of Thailand, they kind of want to know, do I need one for Thailand? If so, will it interact with my international testamentary instrument? You might want to go ahead and contact a legal professional, gain some insight and guidance in how best to proceed.